Gentlemen, good morning, and hope everybody has been safe and sound and awake. This is a code enforcement hearing for the city of North Miami. Today is February 17th, 2022. I am Jose Smith, Special Magistrate for the city of North Miami. The Special Magistrate is empowered under Florida law and the North Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists on your property as observed and cited by a code enforcement officer. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, so all persons who are speaking should do so one at a time.
Recording in progress.
To ensure that all the testimony is clearly audible on the recording device. If folks talk over each other, the record will be unintelligible, and being that we are in Zoom, that makes it even more challenging. If English is not your primary language, then please inform me when I call your case, because we have translators, interpreters who will assist you during these proceedings. When your case is called, the property owner, agent for the property owner, and any witnesses that you may have should announce their presence. When asked, please speak directly into the microphone and say aloud your name, spell it, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney at law representing the property owner, then you must present a notarized power of attorney or an affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you're aware of and understand the violation that is being heard today, and that you understand what is required to resolve the violation. Please answer accordingly. The city will present its case first, and then the property owner or violator will be given an opportunity to testify on their own behalf, to bring forward any witnesses to testify, and to present evidence and photographs. You also have the right to cross-examine the city's witness. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending upon the nature of the case, I will set an abatement or a compliance date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing date should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table or continue this case proceeding to another hearing date in the future. If you do not agree with my findings of fact or my ruling, then the property owner may appeal the administrative order in this case to the circuit court. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record of these proceedings, also called a transcript. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record will be the sole responsibility of the appellant. And it is recommended that persons who plan to appeal their case should provide their own court reporter at this proceeding. If you don't do that, you will not be able to appeal my rulings. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. So are we ready for the Pledge of Allegiance, or is the clerk going to make some remarks?
Yes, Special Magistrate, at this time, the clerk will make her, give her instructions, and then we'll proceed with the pledge and swearing in of the office.
Okay.
And by the way, we have a new clerk.
Excellent.
Good morning.
Welcome aboard.
Thank you. Can you guys hear me loud and clear?
Yes, we can.
Good morning, and thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. Make sure your devices is mute at all times unless you are giving testimony on a case. If you are using two devices to participate in today's hearing, be sure your audio is only enable on one device. When your case is called, if you are signed in into Zoom, you will receive notification giving you access to audio and video so that you may give your testimony. If you are physically here in person and wish to give testimony, you must sign in with the code clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the raise button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist during your case, please indicate that when your case is called. Your magistrate, that concludes the instruction for this morning.
Thank you very much. Are there any amendments or deletions to the agenda?
Yes, there is. Would you like to proceed with the Pledge of Allegiance first?
Yes, let's do that.
I pledge to allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Let's hear the additions, deletions, corrections to the agenda, please, clerk.
Special Magistrate, if we may, can we go ahead and swear in the officers and the translators just before that?
Let's do that.
Okay. If I can have all those giving testimony, with the exception of the translators today, enable their cameras.
Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
At this time, if the translators can enable their cameras to be given the oath.
Okay. Please raise your right hand. Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say, I do.
I do.
Thank you.
Okay, let's proceed.
Okay, Magistrate, can you guys hear me loud and clear?
Yes.
The postponed cases for today's hearing are item number one, 13100 Sunrise Plaza, LLC, case number CEFLR 2021-00087, property address 13120 Northwest 7th Ave, as well as item number two, case number CEZCU 00135, postpone. Item number 3, All Nations Kids, Inc., case number CEBPR 2021-0038, property address 14150 West Dixie Highway, postpone. Item number 4, Build a Concept LLC, and as well as item number 5, Build a Concept LLC, case number CENUS 2021-0056, as well as CEBPR 2021-0015, postpone. Item number 6, Daniel Garcia Tiqueta, case number CESTA 2021-0035, property address 14325 Northeast 8th Avenue, postpone. Item number 7, Dennis Carlo, CESCR 2021-00023, property address 710 Northeast 141st Street, postpone. Item number 8, item number 9, Dorset House Association, Inc., case number CEGMP 2019-00142, as well as case number CESCN 2019-0003, property address 2500 Northeast 135th Street, postpone. Item number 10, Evelyn Jeanette Acosta, case number CESCR 2021-0001, property address 830 Northeast 135th Street, postpone. Item number 11, Joseph Lubin, case number CEBPR 2021-0065, property address 765 Northeast 138th Street, postpone. Item number 12, Grace Chung and Mercedes Chung, case number CERCV 2021-0075, property address 801 Northeast 137th Street, postpone. Item number 17, Joseph Pierre, case number CEGEF 2021-0006, property address 13455 West Dixie Highway, postpone. Item number 14 and item number 15, Karen Mergendumian, case numbers CESCA 2021-0040, as well as CESCR 2021-0027, property address 1330 Northeast 138th Street, postpone. Item number 16, M&G Luxury Services, LLC, case number CEBPR 2021-0094, property address 13820 West Dixie Highway, postpone. Item number 17, Renee Roberto Jill LE, case number CERCV 2021-0084, property address 1440 Northeast 141st Street, postpone. Item number 18 through 20, Salem House Holdings LLC, case numbers CEBPR 2021-0075, CEZCU 2021-00126, and as well as CEEXC 2020-0008, property address 13499 Biscayne Boulevard, postpone. Item number 22, Marilyn Charlize, case number CEFLR 2021-0094, property address 12767 Northeast 10th Avenue, postpone. And lastly, item number 23, Enterprise 305 LLC, CESCA 2021-0002, property address 1865 Keystone Boulevard, postpone. And that concludes all the amendments to the.
Why are we postponing so many cases?
Mr. Magistrate, these cases have been given extensions for various reasons prior to the agenda being posted. Typically, we would not have these on the agenda, but because we had a new clerk, she added them. Although the agenda had not yet been posted, we included these, and they shouldn't have been included. So.
Okay, so are we
received internal extensions prior to them coming to court for their first time?
Okay. So are we ready to proceed with the NOV cases, beginning with item 1?
Yeah.
Yes, we're ready to proceed. Your magistrate.
If I may, I'm sorry. I just found out this morning the case for Madley LLP number 21, 22, and 23 under notice of violations. The opposing party requested a continuance only because they're still in in legislative session in Tallahassee.
Sorry, which case are we talking about?
Under notice of violations number 21, 22, and 23.
Is that Land Trust Service Corp. and Maryland Carlisle and Miar LLP, those 3 cases?
Yes.
And the attorney's name is?
Well, the person who reached out to the city attorney's office is Joe Geller.
Okay.
And he,
he's in Tallahassee. I saw him on TV a couple of nights ago. So if he's counsel of record, then I will continue those 3 cases.
okay.
Did he provide notice identifying himself as being the attorney on record for that individual, Veronique?
He didn't.
I didn't have it.
He didn't indicate that he's the attorney of record. But I just found out this morning, like he had sent an email, and I was just forwarded that email, and I'm just bringing it to you guys' attention. But I can find out if he's the attorney.
Okay.
So, Special Magistrate, I would just like to bring to your attention that this particular property has been deemed unsafe by our building official through the county, and I know that the property owner is here on the call this morning. I did not receive anything from anyone indicating that there was an attorney on behalf of the property owner. And so I appreciate the assistant city attorney, and you defer to you, Special Magistrate, to make the decision on how to proceed with these cases.
Which of the cases involve an unsafe structure?
Well, the building itself, these are separate. These cases are individual cases specific to issues at the property, but the building official has taken the building itself in its entirety as an unsafe structure down to the county. And I do believe Mr. Mark Jean is here as the building official, and I do believe he could speak better to, the unsafe structure component, but I do believe that, in fact, it was deemed unsafe.
All right, so what we're going to do is, by the time we get to those 3 cases, I'd like to see evidence that Attorney Joe Geller has made an appearance as counsel of record, and then I want to hear from the building official. I will decide at that point whether we go forward or not. But I would like to see an official filing from Mr. Geller before I continue.
Not sure, Madam Assistant City Attorney, if you're able to communicate that. The property owner is here. I'm sure he can hear what's being requested. Special Magistrate, I don't know if you want me to give him permission to access the conversation currently, or...
Well, let's all right, let's decide this issue since it's been brought up already, and I don't want to go back to it. Is the property owner present?
I'll give him access. Maxim, if you would enable your audio and video. Mr. Building Official, are you here?
I'm here. Good morning, Mr. Magistrate.
Good morning, sir. Good to see you.
All right.
Which case are we going to take on first? Land Trust, Maryland Carlisle, or Myara LLP, or all of them? Which one do you?
I think you have the wrong one. Number 20 is not a part of this. It's 21 through 23.
Yeah, that's what I meant to say. 21 through. Which case is 21?
All three of them are Myara. Clerk, if you could call the cases.
Item number 21, Myra LLP, case number MHVIO 2021-00108, property address 13200 Northeast 7th Avenue. Item number 22, Myra LLP, case number MHVIO 2021-00109, as well as case number, item number 3, Myra LLP, case number MHVIO 2021-0010.
Yeah, Ms. Patterson, the agenda that I have in front of me is the agenda that was posted on the city's website about 3 days ago. So if the agenda changed, you'll have, I don't have the new agenda, so we'll just have to go through it.
I apologize about that.
Okay. Sir, could you identify yourself for the record?
Morning. My name is Mary.
No, the property owner.
I'm sorry.
I can't hear you. He's muted.
Max, you need to unmute yourself.
Hear me now? Good morning.
Good morning.
Your Majesty, if I may, just a few words. I log into the session to make sure that the hearing is rescheduled. Our counselor is in session, and we've been advised a couple of days ago that the schedule will be this hearing will be rescheduled. But I didn't receive any notification. Just to make sure it's rescheduled, I log into the session.
And your counselor's name is?
Joe Geller.
Do you have a retainer agreement with Mr. Geller?
Of course we do.
Okay, could you provide it to the city attorney?
City attorney is aware. That's Joe Geller is our representative. He's working with us on, it's already like 5 months.
Okay, that may be, but we need proof that he is your attorney of record on these files.
Sure, no problem. The fastest way to verify is to contact the city attorney, Jeff Cazot.
Madam Assistant City Attorney, what evidence do you have that Joe Geller is counsel for this property owner?
As mentioned earlier, what I have is an email that Mr. Geller sent to Mr. Cazot, asking that the case be continued, and as per statute, since he is in legislative session, it must be continued.
So the email went from Mr. Geller, Representative Geller, to the property owner, but the city was not copied on that email.
No, vice versa. It went to Jeff Cazot, city attorney, but that did not came to me.
I'm confused then. Did it go to the city attorney or not?
If I may clarify, Your Honor, and the email went to the city attorney's office, and then it was forwarded to me this morning. And then I forwarded it to code, but they may not have seen it because it was done so close to the hearing.
Do you have a copy? Can you read the email to me?
Of course. One sec. Dear Mr. Apologize. Dear Mr. Cazot, reference is made to the attached notice to appear for Marie LLP scheduled for February 17th at 9:30. As you know, I am in Tallahassee for the legislative session, and I'm unable to appear for this hearing even by Zoom as we have proceedings. Accordingly, pursuant to Florida Statute 11.111, I must notify you of the mandatory continuance of the hearing. Please acknowledge receipt. And he went ahead and said he had 14 violations, 11 of which were remedied and are closed. And there are 3 that are left, which are the ones that are on the docket today.
What's the date of that email?
February 15.
Okay, so my hands are tied because of the legislative immunity in the statute. If Mr. Geller is representing himself as the attorney of record for these properties, then I'm unable to proceed. The continuance would be granted. However, if the building official in his discretion needs to take any action with respect to the Board of Rules and Appeals or any other action condemning properties or shutting down properties, whatever he needs to do, it's totally within his jurisdiction and discretion. So let me hear from the building official as to what actions need to be taken for the protection of the public, considering that this has been deemed an unsafe structure.
Yes, we went. This property was heard on November 10th, 2021, in front of the Miami-Dade Unsafe Structures Board, and there were some conditions that was spelled out, giving them 60 days from November 10th to. Let me see here. I'm gonna read it exactly into the record. A building permit must be obtained for all repairs or items to be completed. The permit document shall be submitted first to the unsafe structure for approval or applicable equivalent in the enforcing municipality. The building permit must be obtained by a qualified property owner or a licensed contractor pursuant to Section 10-5(2) of the Miami-Dade County Code within 60 days, and they took the day from date. So that was done. They complied with getting all 3 permits. The other part of the condition, it says the completion of or repairs of said structures shall conform to the Florida Building Code unless application is made pursuant to the provision of Section 811G of the Code of Miami-Dade County and shall be completed within 180 days from today, meaning November 10th, 2021. Completion shall be determined when a final inspection approval is obtained on the building permit. If any of the above conditions are not complied with, said structure shall be demolished by the enforcing municipality as soon as possible. And the items are listed. It's concrete restoration, railing, trusses must be completed with any incidental work. So that's the conditions that were placed on the property. So
have those conditions been complied with?
The first segment of 60 days, they secured the permit for them. So they're within the still within the 180-day window. Was that equivalent to 6 months from November 10th, 2021?
Yes.
So they're in that timeline. So I went past there probably 2 months ago, but I didn't see that much activity. And I've spoken to Mr. Mack and let him know, you're on a timeline. So I'm not sure whether he can meet that timeline, but I reiterated several times that please make sure he's compliant with that timeline. So,
all right. So what you're explaining to me is that because they have they met the 60-day requirement, they've obtained the building permits, submitted documents. By what is the deadline for completing the work?
180 days from November 10th, 2021. I would have to calculate. That would be 6 months. So
okay,
from that time.
All right. So what you're telling me is that they still have time, but based on your observations, it is unlikely that they're going to be able to finish the construction as mandated by the County Board of Rules and Appeals.
Yes.
Correct?
Correct.
Okay. And so if they do not meet that deadline, you are authorized to seek demolition, correct?
Yes, correct.
And will you do so?
I would definitely declare it unsafe and all the occupants to move out of the property.
Okay, well, it's already been declared unsafe. So the next step is they don't meet the deadline. You're telling me you're going to shut down the building and evict the tenants. How many tenants are there?
There's, I believe, minimum like 60, 65 units in there.
Okay. So it's a what is it, a multifamily?
Yes.
Okay.
Yes, multifamily unit.
Rentals?
Yes, I believe rental.
Okay. I think it would behoove you, the city, to send notices to all the tenants to advise them well in advance before you evict everybody that they should start thinking about moving out.
Okay.
Okay, because if one day you show up with your bulldozers and you start demolishing buildings, I don't think the tenants are going to be very happy about that.
Yeah, we'll give advance notice sooner than later regarding.
Okay, and I'm not making any rulings today because of the immunity that the legislator has, but I'm not prepared to, based on the testimony that not testimony, but on the representations that you're making. If this case comes back to me, 60 days, 90 days from now, whenever it comes back, I'm not granting any extensions, just so that the record is clear. Okay, are we done?
Special Magistrate, just for clarity, if it's okay, I guess, I don't know when your next scheduled hearing is. The clerk could probably better clarify, but we could table these items, I guess, to be heard before you in your next hearing.
Yeah, you can table it. You can bring him back to me, and then I certainly would like a status, hearing just to see where we are, and maybe next time with Zoom and all these other means that we have for legislators to talk to each other. In fact, I spoke to Dottie Joseph the other day on the phone. I had a Zoom conference. We had no problem communicating with each other. So I'm sure that Mr. Geller can arrange the same consideration to the city that he represents. So I'm disappointed that we're not able to move this quicker, but the building official has direction from the county to move forward in the event of non-compliance, and there's not more than I can do. I think we all have to abide by the ruling of the county on this. So yes, but bring it back. Let's see where we are at the next meeting.
Magistrate, your next hearing is April 21st.
All right, so that's when I'll hear it.
Thank you.
I would encourage the owner to move this along quickly, because I believe I may have seen the pictures in the agenda already, and it's not a pretty picture. All right, let's move on.
The next case that we'll begin calling is item number 14, as well as item number 15. Property owner Casa 754 Northeast LLC. Property address 754 Northeast 126th Street. Case number CESTR 2021-0024, as well as CEZCU 2022-00244. Officer Jonathan Lemestre. As far as for item number 14, it is a returning case with the adjudication from November 18th, 2021, and fine set at $1,000.
Okay, I want to hear from the city on the first case, which, just to put it in perspective, it's the advertising, right?
The short-term rental, sir. Yes.
Is it the actual rental or is it the advertising? Or both?
It's short.
If you want to announce yourself first.
I'm sorry. Code Compliance Officer Jonathan Lemestre, and this is for short-term rental. But I just want you to be advised that I have police officers informing me that they're also advertising as well.
All right. So what section of the code are you citing on the first case, the one that has been previously adjudicated?
Give me 1 second, sir.
The magistrate, the section that was cited was LDR 295-1610.
Okay, so it's the actual rental.
Correct.
Yes.
All right. So yeah, let's proceed. Why don't you remind me? And I'm not sure that I was on this case earlier. The 00024 that was adjudicated on November 18th. Fine set at $1,000. And what was the compliance date, or was there a compliance date?
The compliance date for this one was set for, I believe December 3rd.
Okay. All right. So let's proceed, officer. Tell me what this is about.
Yes, Mr. Magistrate. So on September 28th, 2021, September 16th, 2021, the city was made aware that there was a hostel operating in the city of North Miami. During that time, from what I understand, that the property owner leased the property to a tenant, and the tenant operated a hostel on his own. We sent this to the magistrate in November, to Madam Kazu, and she advised that the property owner gives us access to verify if the hostel is still operating. The property owner has not given us access into the property, and from police testimony and from residents in that area, the hostel is still operating as we speak.
I'd just like to add, Magistrate, at that time during that hearing, the property owner did show up as well as the tenant, and they both, I believe, acknowledged that. I believe the property owner did acknowledge that the property was being leased, and there was, I believe, acknowledgement that there was some form of subleasing that was happening, or what have you. Since November, I believe we've received several calls from North Miami Police Department advising that they've been to that location, and the activity, the short-term rental activity continues. If you'd like to hear from the NMPD officers that have responded to that location since the cases were adjudicated, they're here to give testimony as well.
Okay, let me dive into this a little bit. I did review the file, and I know what the officers wrote in their incident report. But is this a hostel? Is it a permitted use in this neighborhood?
No, sir. It's short-term rentals are not allowed in the city of North Miami, and the property is actually a commercial property. So people are living inside a commercial property as we speak.
Well, let me. I think you went too far by saying that short-term rentals are not allowed in the city of North Miami. They're not allowed in residential areas, in single-family neighborhoods. We've already been through this before. If you look at the code sections, it's specifically stated that short-term rentals are prohibited in single-family residential neighborhoods and townhomes. What I'm concerned about is the hostel, because it may not even be a permitted use in this zoning district. Have you looked into that?
If I may, Magistrate, Officer Lemestre is fairly new, so if I can assist him with the case a bit. At this, I can't, unfortunately, I'm not able to recall whether or not the use would be permitted. However, the issue that we're having is that at this time, they have not even come to the city to identify whether or not there is no certificate of use, there is no business tax receipt in order to run the operation in which they're currently running. And so, basically at this point, there's an operation that is not, whether it's permitted or it's not. I'm happy to see if I can get someone from zoning to clarify that for you. But at this time, there is an operation that's running that has not been permitted by the city at this time.
Okay. And in any event, this has already been adjudicated previously. I'd like to hear briefly from the officer. I believe there may have been two officers, correct?
From North Miami Police? Yes, sir.
Yeah, were there two police officers who responded at various times to this property?
Yes, sir. I believe so.
Okay, let me hear from the first one. Tell me why you responded and what did you find? Identify yourself first. Is it Officer Quintero?
Good morning, Magistrate. It's Officer Roll, Miami Police Department.
Very well. Proceed.
Yes, sir. I responded to the address 754 Northeast 126th Street on the 30th of December of 2021, about 12:30 in the morning. I got a call from a Mr. Olson, who identified himself as the owner. He stated that there was a person inside the residence that was squatting. He advised that he was not able to be on scene at the time. However, he was in California, and the person that he identified as the squatter was a person by the name of Lisa Beckford. He said she was trespassing on the property and he wanted her removed. However, he went on to state that he allowed her to lodge at this location for an unspecified period of time. And he also said that he billed her for her stay at the property. She left on her own recognizance, he said, but she returned and tried to resume lodging at the location, but he refused at that particular time. I asked him why did he refuse her, and he said he no longer wanted her services. At that time, I continued to ask him questions in regards to the lodging of the resident, and he said that it was quoted, he mentioned specifically a C3 business property, and its primary function is a dental facility. It was pretty much zoned for business purposes, not short-term rental or any type of lodge or hotel or motel. And I asked him, well, how is it that he wants to charge a person for lodging at the same time it's not zoned in the residential area for that type of business? He responded to me that he was working it out with the city and it was complicated. And I ended the conversation with him. I then proceeded to speak to the person that he wanted to be removed from the property. And she said that she found out that this hostel was through Craigslist, listed through Craigslist. That's how she found out about it. She made an agreement with the owner that she would be terminating her stay on January 5th. And she made payments to him in the amount of $161. She said she made these payments via Zelle. She pretty much said that he didn't object to her staying. She didn't know the reason as to why we were on scene at the particular time, wanting her to or requesting her but we didn't request it, but why he was requesting for her to leave the property. We explained the situation to her, and she actually said that she did not know that he was operating this particular address on the website illegally, unbeknownst to the city. So once I entered the property, that's when I observed the setup, the layout. There was a washer dryer setup. There was a room to the east that was filled with bunk beds and mattresses, all of which they were occupied with person. There was a room to the north of that. There was a kitchen, and every room was occupied with mattresses on the floor. And the kitchen was set up with utensils and cookware, things of that nature. There were many tenants that came to me, and they were expressing their dislike for the services that they were receiving, and they were pretty much stating that the conditions that they were paying for wasn't the same advertisement that they received once they committed to payment to the owner. At that point, I was unable to speak to him again because he had his sister on scene, who was supposedly the manager for the hostel, but she was not. I was unable to speak to her. And at that point, I was able to document the event, and I forwarded it to the appropriate department within the city.
Okay, let me stop you there. What is the date of your visit?
It was the 30th of December, 2021.
Okay. All right, I think I've heard enough, Officer Rowe. I believe that I understand what this is about. Was there another officer that wanted to testify on this case? No? Okay.
Hello, Officer Quintin.
Yeah, go ahead.
No, I'm okay. I'm just going to be redundant because I was off the rolls back up. But yeah, multiple people. The only thing I'll add on is multiple people were coming up to us and talking about the conditions of the establishment that there was. And that's pretty much it. But yeah, that's it. Thank you.
Okay. Yeah, we don't need to be redundant. Yes. Is the property owner here?
Hello. Yes, that's me.
Okay.
Before
what
you
is
begin,
your defense?
Magistrate,
Has she been sworn?
Not yet.
No.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
There's
All right,
Jackie Perez here also. Did you intend to speak, Ms. Perez, or because you need to be sworn in? Is she here with you, Fernando?
No.
Fernando?
No, not with me.
Okay. Sorry.
You're the owner of the property?
Yes, my family's the owner of this property.
Okay. What's going on with this hostel situation? Are you operating it as a hostel?
No, I leased this space. I was not aware of it being leased. I had no idea he was running a hostel without proper permits and certifications. And when I was made aware of this, which was last November, September is when we got the violation. We worked with him. I came to this hearing. There was a special magistrate, I think November 17th. A lot of the activity that was happening there, I had no idea. I didn't even know it was a hostel. I thought he had all of his certificate of use. I thought he had everything because I had signed off and written a letter for him as property owner when he leased the space. Because he would need to change the use for what he wanted to do. That was obvious. Otherwise, it'd have to be what it's currently. It's a C3, but it's currently.
It's zoned as professional services.
Yes.
It's zoned as professional services, magistrate. So they would have to, they would have to go about changing the use.
And so after the hearing, he wanted to. I gave him, the minute I heard about it, I can only work with my lease at that moment. I sent I told him to stop it immediately, and I did this in writing. Stop all operations until he gets the proper licenses and certifications. It's a breach of our lease. Then he reached out to me and wanted to work on it. So he sent me all the information, and we went back and forth, and we had a conversation with the county fire department. And then I realized he had a lot of people in there. The space isn't up to code for such quantities of people. And basically, we sent him a notice to evict. And we're in that process of evicting him. We actually just filed, the clerk entered a default against the tenants. So that just happened this week. And once that order is obtained, then the police can go in and remove whoever's from the property. My hands are really tied here because we are trying to get rid of them. But we're going through the eviction process.
Do you have a copy of the notice of default?
I have an email from the lawyers, but I can send you a copy. They should have it.
Can you send that to the city attorney?
Of course I can. At this moment, do you want me to email them now to send it to them, or after the meeting?
You can do it after the meeting.
Yes, definitely. So my understanding, we sent him the eviction notice January 4th. So we're in the process. We're very, very, very close. I have a lot of things hanging on this. In that, we have this violation, then I have a certificate of use violation on my end, and a BT. So there's a lot of things going on, and it's until this tenant's out of there, we cannot do anything. But he's soon to be out of there. And I've spoken a lot with Mr. Lemastre, and I've even spoken with the community development and department regarding what he can and can't do. It's just at this moment, he's operating something that he's not allowed to operate. He breached our lease by not having the proper certifications, and we've officially sent a notice to evict, and we're very close to having him out of there.
Do you have anything scheduled with a judge?
I can find out from the lawyer. I received this notification Monday that the clerk entered a default against the tenants.
Okay, so the next step your lawyer will advise you is to go in front of the judge and get your default. City, what is your recommendation?
We're okay with, based on the property owner's testimony, we're okay with tabling and seeing what happens in the next 30 days on this issue. We would just request, magistrate, that I believe the short-term rental item had already been adjudicated. I don't believe the certificate of use had been adjudicated. I think that, so if you would enter an adjudication on that item, we're okay with allowing another 30 days to see where things land with the tenant.
Well, let me, the certificate of use for what?
It would be
for the landlord.
Property owner. Yeah, so in order to be able to sublease or to lease the building or to provide commercial real estate services, she should have had a certificate of use in the first place prior to leasing the space.
I didn't know about that, and I didn't know about that. And the minute I received that notice in August, and then I immediately called to figure out how to get it, because that's not a big deal. In order to get it, I have everything filled out. The one thing that is pending is the fire inspection. I have an old fire inspection from January, but that doesn't qualify. And so in meeting with the fire inspector who did a failed fire inspection for the VC, they said that basically he needs to call in fire inspection, and there's no way he's going to pass with the operation he's running. So I can't get that until he's out of there. I have all the paperwork filled out. It's very easy. I have the letter. I just need a fire inspection stating that the space is safe, basically.
So actually, I would say, magistrate, if instead of the 30 days, since you'll be back in April, if we could set these items to be heard before you in April, but just enter the adjudication on their certificate of use.
Just so that I'm clear on what I'm ruling on. The current zoning allows the property to be used for professional services. Is that correct?
That's correct.
Okay, and the property owner is seeking a change of use from professional services to rental.
No.
No, she's evicting the current tenant, and I get my guess is that she'll be seeking to obtain her certificate of use for professional services, and at some point releasing the space to someone that's going to be doing professional services.
Okay, so there is no change of use.
No.
Okay.
No, but my understanding is I need a change of use as a proper, which is why I didn't have one. I didn't know that. Owning the actual property, we need a certificate of use, which we didn't do before we leased.
I get that you need a certificate of use, but you're not changing the use to something else.
I am not changing the use to anything. No.
Okay.
The use is as it is. If we get a renter who wants to change the use, we support that, but that needs to be done legally through a process that the city has established, which this tenant did not do.
Well, I'm convinced of the credibility of the property owner, the good faith of the property owner, the fact that she has taken the initiative to seek to evict. I would encourage the property owner to get a court hearing as soon as possible. Maybe seek injunctive relief to not only evict, but perhaps even quicker, remove those people even before the proceedings are finalized, because clearly it's in violation of law. So what my ruling, based on the testimony of the city's code compliance officer, the testimony of the property owner, the code officers, having found that proper notice has been given, I find in favor of the city, and I enter an adjudication based on the zoning violation, the use certificate of use, and set a compliance date of basically next hearing that I have.
That's April 8th.
April 8th. That's when we have to have compliance. And in the event of non-compliance, there will be a daily fine of $250 until the violation is abated.
Special Magistrate, I would, if you would consider, we would request that in addition to the ruling, that you would enter an order that the operation cease and desist until such time that the eviction has gone through. We would, then prepare that cease and desist notice, and the police department would then be able to enforce that if it were your ruling.
Yes, that would be my ruling as well. And I wanted to get clarification on the prior adjudication, which set a fine of $1,000 a day. Where does that stand?
It has not been ratified. And so I think based on her testimony today, seeing as this is the first time she's come back since that ruling was made. So I would be okay with not ratifying the fine, provided that we entered or that we were able to proceed with the cease and desist. Yes.
I order that the city is authorized to issue cease and desist of all activities ongoing inside the property, and that the city take whatever action is necessary to make that happen.
Thank you.
Okay. All right. Move on to the next case.
May I ask?
Sorry, I muted you. You might need to unmute yourself.
Okay, to whom should I email
The city attorney.
The city attorney? Okay. And then just put the note of the actual case number on it.
Yeah, and I'd like the city attorney to monitor the eviction proceedings, and by the time we meet again, be prepared to advise me as to what the status is of that eviction.
Oh, I can't wait to advise you with good news. Thank you very much.
Great.
Thank you.
We'll proceed with item number 2. property owner 12610 Northeast Holdings, LLC, case number CEFLR 2021-00093, Officer Aaron Barber.
And we realize your agenda is different, Magistrate, so I don't know if my clerk can.
Is it 12610 Northeast 11th Avenue?
Yes.
Yes, it is.
I'm on it.
Okay. We have an attorney, the law offices of Deeb and Deeb, here on behalf of this property. You may want to unmute yourself, sir.
Good morning.
Good morning, Mr. Deeb. Let me hear from the city first.
Aaron Barber, City of North Miami Code Compliance. This is a new case for the business tax receipt. Case was opened on September 28th and notice to appear posted on January 25th of 2022. And as of the final recheck date on February 5th, 2022, there was no BTR found in our system, no business tax receipt found in the system. This was for JL International Investment.
Your Honor, if I may?
Yeah, wait. I because my agenda has a different numbering system. Tell me again what the address is.
12610 Northeast 11th Avenue. And it's under property owner 12610.
Okay. Okay. Business tax receipt violation. Mr. Attorney, tell us who you are and who do you represent?
My name is Kevin Deeb. I represent 12610 Northeast Holdings, LLC. I was just brought into this case primarily because the property owners first weren't aware of the business tax requirement, and they need assistance getting it. They're in the process of it. I do not have any information. I'm supposed to meet with them. I tried to meet with them before the hearing. I couldn't. I suppose that we can have it shortly. I asked that either, I don't know what the process would be. If we could defer to the next hearing, we would certainly have it before then. I see that it's an October 18th notice of violation. So it's been a little bit of time, but they're in the process of getting it. I imagine it shouldn't have taken this long. But that's why they brought me in to see if we can expedite it and get it done.
All right. This is what in the old days used to be called certificate of occupancy. Now they're calling it business tax receipt. It's really nothing more than just going and paying a tax, filling out an application and paying a tax. Not a very difficult process. What I will do is I will give you 30 days within which your clients can come to the city and do the paperwork and pay the tax and be done with it. It should not be very complicated. So based on the unrebutted testimony of the city's code compliance officer, the evidence presented, we find that the violation is still in effect. Proper notice has been given, and I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $100 until the violation is abated. So you have 30 days to comply. If for whatever reason, possibility or something else comes up, some other code violation that results in your client not being able to get a certificate of a business tax receipt, then you come back in April and explain that to me. But right now, 30 days should be sufficient. So thank you, sir. Appreciate it.
Thank you. Thank you.
All right, next case.
The next case we'll be calling is item number 26, which is under property owner Northeast 17th Ave, Corp. Property address 13267 Northeast 17th Avenue, Case number MHVIO 2021-0005. Officer Gary Beswick.
All right. Remodeling a bathroom and installing freezers without permits. Is the property owner present?
Yes, his representative is Kevin Burns.
Okay, Mr. Burns. Glad you're with us. You're the attorney representing the corporation?
No, I'm their registered agent, registered lobbyist on their behalf.
Okay. So in what capacity are you testifying?
They hired me to resolve this issue for them, and I'm here to speak on their behalf, and I'm registered with the city.
Okay. Let me hear from the city.
Good morning, Gary Beswick for the City of North Miami Building Department. The property was started back on January the 6th of last year to fail to obtain all required permits for some work that was done. They finally applied for the permit yesterday. So what we're seeking is adjudication and abatement date.
All right. Do you have any pictures? There they are. That's what I'm looking for. So point out to me the bathroom renovation first.
Okay. Go back up, down, right here.
There you go, on the lower left-hand side.
Yes.
Okay. So what does the picture depict?
Bathroom is new.
Okay. And then the freezer, that's the freezer?
Yes.
Okay. What kind of business is this?
Like a catering.
Catering. Yeah. Okay. No issue with the zoning?
Well, that's why I went there. I went there for an inspection for certificate of use. That's what I observed.
Okay. So did they get a certificate of use?
No.
All right. But that's not before me today, is it?
No.
Okay. The issue is, do they have permits? Have they pulled permits? And are they moving forward with those permits, right?
Yes, they applied for it yesterday.
All right. Mr. Burns, let me hear from you.
Good afternoon, sir. Pleasure to see you again, and also the city staff. I want to briefly give you a background on this. The business has been existing there for many years. They got an emergency contract through Homeland Security and USDA for emergency COVID relief, prepare an additional thousands of meals a day for the federal government to service the most needy during the COVID crisis, the pandemic. And as you know, by this meeting, we are still within the pandemic and the issues, and that's why we're meeting by Zoom. There was a vacant bay next door to them. Through the USDA guidelines, this vacant spot next door was a former automobile repair place. They hired a licensed contractor to do the work and pull the permits. The contractor did all the work, but had failed to pull the permits that the owner of the catering service actually paid them for. They called for the certificate of use. The applicant called for it, and Gary came out and said, well, there was some work done without permits. And they said, no, we hired a contractor. He pulled all the permits. We go to find out that the contractor did not. They tried to resolve the issue with the general contractor, and the going back and forth for several weeks, and it got nowhere. Somebody referred them to me that I could help them, get legal and go through the process. They told me what happened. I spoke with the contractor, and it was a lost cause. He wasn't gonna do anything. I immediately went to the former chief building official, and he came out and personally inspected the property because we wanted to make sure, and I wanted to make sure to represent this client, that there was no immediate threat violation. Even just us making a visit through there, because it was the height of the COVID, they're processing thousands of meals for the USDA under this emergency order. we just can't walk in there. We had to follow certain protocols. We went in there. The chief building official, Steve, looked at everything. He says, everything is good. There's no health safety issue. We just need to do after the fact permit, start from scratch with a new contractor. So the owner of the business, we hired a licensed architect who's very familiar with North Miami. Again, height of COVID. You just don't walk in there and measure the building. And it was very difficult to get the architect in there. He created the plan. And I brought those plans to the building department many, many times just to make sure we had everything correct because I wanted to make this a one-shot deal. We hired a general contractor and we're getting ready. It's not easy to hire a contractor to certify somebody else's work, to do an after-the-fact permit for the bathroom was existing. They changed the fixtures according to the way to meet ADA, to meet USDA guidelines. They added an additional wash sink that they wanted, and they had to install the self-contained freezer. We got the contractor. Go to find out after a month and a half that the contractor's license was in probation, which he was not allowed to pull after the fact permits. He could pull regular permits, but could not pull after the fact permits. We secured another contractor. They wanted to review the plans. They wanted to review the whole history of the project, and then was able to get them to execute the building permits yesterday. This is now in the process going to the county to Durham the fire. The building is not, or the use is not unsafe. I'm in that building department several times a week, and I convey with them, not just with this case, but other cases. And the former building official was very generous. He says, we have no intention, or our intention is not to shut down, especially what they're doing, providing these meals, and the operation is fine. You just got to get the paperwork done. They, again, hired me to help them assist this. And in these times, things are not simple. It's not simple to get contracts, not simple to get art, but we got all that. And we're now in the process. And the fact that I'm actually here today, I was kind of, disappointed that we couldn't, again, ask for a continuance on this, because good faith is being made every single day. The owner has gone through COVID, the whole 9 yards. But that's a different story. They thought they did the right thing by hiring a licensed contractor to do the work. They called for the original inspection, and that's how this all got to be where we're at.
All right. I appreciate the history, Mr. Burns. I just have a couple of questions. The equipment that is in there, the freezer, is that the owner's property, or was that put in by the government?
That was put in as a requirement by the government, but his equipment. They told him he needed more freezer space for the capacity, and he added that in there. And it was under a lot of stress that they said, you have to get this. We're in a crisis mode. So
And,
it wasn't so.
it's operational.
Yes, sir.
It's still providing meals.
Yes, sir.
And is there a contract with Homeland Security or the federal government that applies to your operation?
Yes, it does. They have a contract to provide a certain number of meals per day and distribute it. They distribute up to West Palm Beach. Also, I want to note that the fire department has been in there and has passed a regular inspection. The USDA is in there constantly making sure that the health and safety and everything else is operational there because they're providing a crucial service.
All right. So you currently obtained a building permit.
No. Apply for a permit.
Applied for a permit. Okay.
The plans are in review.
All right. And the permit would be for the bathroom renovations, or is there more to it than just that?
The plans that we submitted are for the bathroom renovations, the addition of the two walk-in coolers, and the placement of a additional sink that's there, and expansion of changing a storage room into office spaces and adding doors and changing it from storage to office space and enlarging it. That's
Okay,
what the plans call for.
Mr. Beswick, what is the process now that they've obtained a building permit? What happens next?
No. They apply. You keep on saying they obtain. They haven't obtained anything. They apply for a permit.
They applied for a permit. What's
Now
the
it's
next
gone to
step?
Durham. It's in the Miami-Dade County. Now it's gone to Miami-Dade County for review.
For Durham?
Yes.
Okay, so how long does that whole process take?
We have no control over that. I don't know.
Okay. City, what is your recommendation? Crystal,
It's my case. We're seeking adjudication with abatement date.
Okay, how much time do you want to give them?
Whatever time we need. We need adjudication.
Okay, how much time do you need, Mr. Burns?
We're down at Durham and Fire, and they can take 2 weeks or they can take 60 days or so forth. I believe you said you have a hearing scheduled for April. I would believe if you could allow us until April, we should, because the work is already completed. They just have to sign off on the plans as built and then issue the permit, and we'll get the final inspections.
Okay,
If you could give us to April.
Yeah, you're not doing any additional work. You just
No, sir.
It's an after the fact permit.
Correct.
All right. So based on the testimony of the city's code compliance officer, having heard from the agent for the property owner, having reviewed the photographs and the evidence presented, I find that the violation exists and that proper notice was given. I find in favor of the city enter an adjudication and set a compliance date of my next hearing date.
April 8th.
Right, April 8th. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Your Honor, I was just looking at the calendar. I forgot what we're at the end of February. That's March and April. I don't know if we're going to get that back from the county. I was, for some reason, we were in January. If you could give us 90 days so that we do not have any issue whatsoever, then we come back, we're going to say it's resolved. I believe that's more realistic than 5 or 6 weeks from now.
If when I rehear the case in April, if you're acting in good faith, moving along, and you're not foot dragging or stonewalling me, I'll give you more time. But for now,
Thank you.
let's shoot for April.
Okay, very good. Thank you.
All right, thank you.
The next item that I'll be calling is item number 11, 12, and 13. Property owner AHDS Ocean King LLC. The case numbers are CEMHS 2021-00107, CEMHS 2021-00108, CEWAL 2021-0001, property address 14500-14560, Northeast 6th Avenue, Officer Christopher Colson.
All right, we have 3 cases, right?
Yes.
Are we going to hear them one at a time? Let's hear them one at a time. Let's hear the first one first.
I'm sorry, Mr. Magistrate. It should be 4 cases.
1, 2. I have, I believe I have 3.
3 cases. It's only 3 cases.
I heard the one ending in 107, 108.
Yeah,
004.
Yeah. Sir, please let me conduct the hearing. And don't speak until you're called upon, please.
Yes, sir.
Let me first hear from the code officer on the first case, which is 2021-00107. Okay, annual housing inspection. I want to hear that case first. Okay, it deals with balconies, cracking, exposed rebar, on property. That's the case we're hearing right now. So, city, whoever's handling it, Christopher Colson.
Mark, if you want to, before he starts, just swear them in, please.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
I do. Good morning.
Okay, let me first hear from the city.
Good morning. My name is Officer Colson, Code Compliance City of North Miami. This is a new case. This case involved the cracking of the rebar. It was a minimum housing investigation. Originally opened back in back in September. This case was originally opened. As a final inspection, the violation still remains. The pictures are in the TCM. Been in there several times. You still see the cracking in the rebar. They said, when I talked to the property owner at the time, so they said, and they were going to get some bids and stuff and see about painting and everything and doing restoration, but none of that has happened as of the final reinspection, Your Honor.
Okay. I see the balconies, but I see other things in those photographs. So we'll get to the other cases later, but let's deal with the case at hand. Mr. Martinez, you want to speak to the violations?
Yes, sir, I do.
Go ahead.
I have a permit submitted for the balcony to be demolished and replaced, balcony balusters. That's been submitted since November 20th, and it's still in plans review with the city of North Miami. We also have secured all the balconies to prevent any tenant or any access to the balcony in meantime to make sure they're safe. And
how did you do that?
We had my structural engineer provide a method of securing the balcony sliders so no tenant can access. And what we did was we boarded it up with plywood and 2x4 members. And that's securely fastened with concrete anchors to the actual face of the building. So the slider can be opened, but they're 48 inches tall, which actually exceed the code for fall protection and do not prevent any egress in case of an emergency or a fire for someone to be rescued. So we took all precautionary measures to make sure that that building is safe until permits are obtained.
All right, so your applications for a permit are being reviewed by the building department?
Yes, sir.
What would be the next step? Do you have a contractor ready to go?
Yes, I will be performing the work. Yeah, in order for us to secure a permit application, we have to have a contractor sign the permit application. So that work is already secured and ready to go, but no work can commence, no painting of the building is recommended at the time because there will be construction in progress. And that's the reason why the cracking still exists. The other, well, okay, so that's it.
So you're a licensed contractor?
Yes, sir.
Okay, and who submitted the application for a permit?
I did.
Okay. How much time do you think you'll need?
That's going to be depending on the city. I submitted it November 20th, and they're still not done with their plans review. I actually went personally last week just to see before the hearing to make sure that it's not collecting dust somewhere, but they said they're working diligently on it. They are understaffed, and it's just going to have to be an order which they received it at.
Okay, Mr. Colson, Officer Colson, what do you say to that?
I have no problem with that, but the building official did go out there yesterday and take a look at some things, so I would like to bring him in on this too, if that's okay with you, Your Honor.
Absolutely. Any life safety issues?
The hazard that I see is basically overhead hazard, because if there's any debris debris that can fall from above, and there's someone walking there, and any vehicles that kind of.
You want him to put up a net?
I'm trying to see how possible, how feasible it is to kind of the balconies probably that are in worse condition. They might have to kind of wrap them around with a net just to avoid something from falling. But now, so that way I could be clear. The balconies are inaccessible currently.
Mr. Martinez, can you answer that?
They have plywood covering the slider, opening of the slider up to 48 inches tall. So if you open up the slider, you still have, what would be a plywood handrail, but it's fastened with concrete anchors to the building itself. So you cannot step onto the balcony, but you can open the slider. And we didn't cover it all the way up because of any egress issues that could prevent.
Okay. And what does your engineer recommend as a precautionary measure for any debris that's falling from above?
I would recommend the same things. Wrap them with net. It's mainly on the concrete that is falling. The majority, and I would say about 97% of that, it has to do with the concrete balcony balusters. But yes, absolutely, I would agree which putting that up would be the safe and prudent thing to do. And we can get that done right away.
Okay.
All right, that would be part of whatever order I enter, is that you take any and all necessary precautions as may be recommended by the building official to ensure the public safety. Mr. Building Official, how much time do you believe they need in order to move along, get the permits, get the work done?
And also, I wanted to find out with him, because I stopped in the office, wanted to make sure, has the plans been submitted to the county, and have they come back from the county? Because I want to make sure to understand what's the holdup.
Well, I can give you that permit number.
Okay, I'm ready for it.
B as in building, R as in Robert, 00-2021-00480.
Mr. Magistrate, can I look it up real quick to see the status?
Sure.
Okay,
sure.
Thank you.
Go ahead. While we wait for the building official to look up the case number, perhaps we want to move on to the next case, which is again, minimum housing inspections for fixing fences and walls on the property. This is now we're away from the balcony issue. We're into the fences. Officer Olson, can you just show me some pictures?
Officer Colson, and yes, we should have pictures coming up in a second.
Point out what the problem.
Go back down to the first one. It's the front wall. As soon as you enter the property, you have the rebar showing at the bottom, and most of this, it needs to be cleaned and pressure washed and painted also. And this is just another wall up and down the building. Mildew coming down. Probably not doing a good shot, but it's a mildew.
What fences are we talking about?
Talking about the front entry fence to the property. As soon as you turn into the property, it's not a life safety issue with that. It just needs to be fixed and redone. It's not blocking anything.
And the walls are the walls that you just showed me that require
painting.
Painting?
Yes,
okay.
Painting and pressure wash.
Mr. Martinez, any comment?
The walls have been notated as part of the concrete restoration work. Those will be repaired as part of our permits. So we can certainly address that once we have the permit, because it will be required to do masonry work. And as far as the mildew on the wall, I believe we can get that power washed and have that cleaned up for them.
Okay, so I guess we do have three cases. We have 07, 08, and 01. I guess we can, for purposes of expediting this, because they all fall under the same permit, correct, Mr. Martinez?
Yes.
All right, so they all fall under the same permit. So it's fences, walls, painting the entire building, fixing the balconies, which appears to be the more challenging thing from everything I've seen. So let me turn over. Let me ask the building official how much time is necessary to get this done.
All right. Mr. Magistrate, I took a look at it. They had some structural denial, but it seemed like two minor comments. So what we'll try to do, try to get on this expedited real quick, so that way the gentleman, Mr. Martinez, could obtain his permit. Now, Mr. Martinez, when you obtain your permit, how long would that take for you to complete the work?
Well, our proposal is to remove the concrete balusters, demolition, secure any catwalks and balconies during that portion. And at the same time, while demolition is being performed, we're going to order lightweight aluminum, powder-coated aluminum handrails or balusters to be installed. So fabrication is usually, from when I submitted the permit, it was around 4 to 6 weeks for fabrication and delivery. And then the installation, I estimated, would take anywhere from 6 to 10 weeks. It depends, because I don't want to get rid of all concrete balusters and have to secure all the balconies and prevent, any injury, because this is an operating building and tenant. So I was going to do it in stages. So have an entire row of, a certain amount of linear feet and just go up that, then transfer over our scaffolds and then continue working in that manner. So that way it's not an inconvenience to also building tenants, because I will be taking up a lot of their parking space in order to perform this work. So when permits are issued, I can estimate anywhere from 10 to 12 weeks, give or take, and that all depends, on supplies. So, and it's been really tough. And as a building official, I'm sure you're hearing the same story all the time. But as of right now, I think it's about a 10 to 12 week project. It's not a really lengthy project, but it will have to be done in stages.
Mr. Magistrate, I guess I can give him. I'm figuring, within 2 weeks, hopefully he should get his permit secured. Then it's a matter of him conducting the work. Now, also, when I was out there, a tenant brought me into a unit, and it seemed like there's some roof leaks as well, because she had some mold pores in there. So I believe this is work that's that you have to do to complete a 40-year recertification as well, right?
Yes, that's going to be all part of it. As a matter of fact, the structural engineer who provided the drawings will be completing the 40-year recertification and provide a clean bill of health. And any roof work that needs to be done will be part of that 40-year as required by Miami-Dade County.
Okay.
All right. Mr. Building Official, the only question I have of you is, considering that there are tenants residing on the property and that extensive work is going to be done, do you anticipate any life safety issues? And if you do, what mitigation activities, what can be done to prevent any potential injuries or death?
Mr. Martinez could submit that sign and seal engineer report with any precautionary measures that his engineer needs to do, and he needs to get on that right away. Doesn't need any permits for the precautionary measures. So that's something immediately you can do upon my review of that document. So I guess with cautionary measures, can you do that in a week, or how long to put the netting to prevent any debris from falling?
Yeah, I would say 2 weeks. We're already at Thursday today. Just let me get 2 weeks and I can have that in your inbox. Do you mind giving me your email? I believe you're a new building official. Is that right?
Yes. Yes. It's Jean-Marc at northmiamifl.gov.
And that's Mark M-A-R-C.
And I'll put it in the chat.
Okay, great.
Okay. So I guess for the precautionary measures, two weeks, Your Honor?
Yeah, absolutely. Actually, it's entirely up to you, and I would encourage you to keep your eye on the ball and make sure that there are no life safety issues. And if you find anything, bring it to the attention of the property owner and the contractor. And hopefully they'll comply. But if not, that stop work order book that you have in your office is always a good incentive for people to comply.
Okay, we'll do.
Okay. By the way, Mr. Martinez, are you the owner or just the general contractor?
General contractor, owner sitting right next to me.
Okay. We're not going to look back. We're going to look forward. So what I'm going to do is I am going to find that the violations. As to the violations, I'm going to find in favor of the city, and also enter an adjudication and set an abatement date of 90 days. Assuming that you're in compliance with the requirements of the building official at all times. And in the event of non-compliance, there shall be a daily fine of $500 until the violations are abated. Stated differently, I'm giving you 90 days to complete the work. If the work is not completed within 90 days, then potentially the $500 a day fine will accrue. So you got to get moving. And I would appreciate if by my next calendar hearing in April, I'd like to hear a status report just to make sure that everything is going appropriately. I don't know whether the city does these status reports, but if we can get one in April, I would appreciate it.
Magistrate, just to confirm, you're not setting it for April, you're setting it for June. That would be the 90 days.
Yes.
It'll be June 16th for the next hearing, and as for the abatement, June 3rd.
Right, and I'm also asking that I be advised, because it is at least as to the balconies, I'm concerned about that. I'd like to know in April, during my April calendar, I want to bring back the owner and the building official to make sure that they're moving along swiftly and that the public interest is being protected. I'm not going to make any rulings in April. I just want to be advised that everything is being done according to my order.
Special Magistrate, would you consider that the general contractor submit something to the building official in writing that can be then submitted to you on that date or prior to?
I think that it should be something submitted to the building official for the building official's review and analysis. And if the building official deems that there's anything that is not being done right, then he should bring it to my attention at the next hearing. But if everything is working the way it's supposed to, then I don't need to hear it.
Okay, so Mr. Martinez, I guess as part of the order, if you would be in contact in writing with the building official, and please include the code department in order to be able to accommodate the magistrate's request.
Yes, ma'am.
Any life safety issues that arise between now and April, or if there's any kind of non-compliance or new issues come up, like I just heard leaks and mold. If something like that comes up in the interim, I want to hear it. I want to hear it.
But this question, which unit do you not happen to have that, Mr. Building Official? Which unit number was that, the complaint? Just to get that addressed as well.
If it's okay, Special Magistrate, Mr. Martinez, and Mr. GC, if you guys can follow up with the building official so we can move forward. You guys can, he had provided his email. If you guys can follow up with him so we can move on with the agenda.
Yes, ma'am. Moving on with the agenda, I believe we missed one case number. Can I repeat that number to you that I don't believe we addressed?
There's only 3 cases, 107, 108, and 001.
The case you're referring to was closed out. It was in compliance. It was closed out.
CESEA 2021-00004?
Yes, it was closed out.
Thank you very much. I appreciate you guys' time.
Closed out. All right. Good luck.
Right, bye-bye.
Next case.
We'll proceed with item number 24. Property owner Moses Garcia, case number CEBPR 2021-0015, address 12930 Aurelia Road, Officer Jose Perez.
Anybody here on behalf of the owner?
Yes. Mr. Garcia would enable your audio and video.
Good morning, Mr. Garcia.
Morning.
You're appearing on behalf of the owner. You are the owner?
Yes.
Single family home?
Yes.
All right. This matter involves a...
Magistrate, before you begin, can I administrate the oath?
Yes, please go ahead.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give in these proceedings shall be the truth, the whole truth, and nothing but the whole truth? So help you God. Please say I do.
I do.
All right. Let me hear from the city.
Good morning. Officer Perez with the City of North Miami. Today we're hearing the case in regards to the property at 12930 Aurelia Road. This case is in regards to construction that was done without permits. In this specific case, we're talking about some remodeling done to the pool that was done and no permits have been obtained. As of my final reinspection date on February 10th, no permits have been obtained for that.
Let me see. Okay, I see a pool. I see a seawall. Is the seawall okay?
Yes, the seawall's fine. There's other stuff that was going on without permits as well, but the seawall was not touched. This specific case is coming forward for the pool by itself.
All right. Mr. Garcia, tell me about why you don't have a permit for the pool remodeling.
Yeah, so what was happening with the pool was there was a leak, so it was losing water. And I hired someone to come and repair the leak. They had to break some of the surrounding area in order to repair some of the pipes that were causing the leak. So yes, the work was being done and a permit was not pulled, but the pool was existing. I have since then, been in the process of trying to find someone to help me with the process of, because I went to the city and I spoke to Mr. Joe Perez. He said, yeah, just obtain permits for what's being done. And that'll be that. But it wasn't, when you go to the city, obtaining a permit isn't something that it's very easy to do. So after several attempts, contacting different people, they would come and say, okay, I'm going to let you know, what we can do for you. A lot of people never got back to me, never, helped me with the situation. But I finally have already obtained a contractor and an engineer who has come and is already drawing plans for the pool work that was done, and a contractor that is working in conjunction with him to then submit the permits and basically come into compliance with the violation. But it's been something that wasn't easy to get done. It's in the process. Right now, a permit has not been obtained yet because all these things, the drawings and all these things need to be obtained in order to be submitted so that the permit can be reviewed. And my sole purpose here today is to, and the word from the contractors, to explain what's going on and to request an extension so that next time, I present myself, we already have, the permits for after the fact, which is what's being worked on.
Okay, when was the work done?
I don't have that information, but I'm sure Mr. Perez can.
Violation was open on September 21 of 2021.
So the work was done on or about September?
Yeah, that's what was being done.
Okay, Mr. Perez, the testimony from the property owner is that there was a leak and he needed to fix it. And he went about fixing it. Was it ever fixed, or was work stopped?
Yes. The leak was fixed, and the job was finished. So that was also part of the issue. Meaning, a lot of people that came in, not a lot of people want to go through the work that it is of already something that's been done and it wasn't done by them. So I was finally able to get someone who put me in touch with a contractor who was able to verify the things that were done with photos that I gave him and all that stuff. So this person actually took on the job, and that's what the process we're in right now.
Okay, thank you. Officer Perez, what is your recommendation? I know what you're going to tell me, so I'm just going to go ahead and make an adjudication and give him time to correct.
That was going to be my recommendation.
No, I've heard it before. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice having been given, I find in favor of the city. Enter an adjudication and set a compliance abatement date of 90 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Thank you, sir. You got 90 days.
Okay, thank you very much. All right. Bye.
Next.
We'll proceed with item number 25. Najleen Isidore, case number CEGMP 20210040, property address 1631 Northwest 119th Street. Officer Aaron Barber.
Anybody present on behalf of the owner?
Yes. Just a moment if they access the meeting. Najleen, if you can accept the invitation to enable your audio and video. Najleen, are you there? You can speak. We can hear you. You're not muted. All right, we may have to skip your case. Najleen, are you there?
I see her, but no audio.
She has audio. She's just not speaking. All right, Magistrate, if you'd like, maybe she needs a moment to gather herself. We can move to the next case.
On. Yes.
You're muted, Peggy. You're muted.
Sorry. We'll proceed with item number 27 through 35. Property owner NJZ and property address 13355 Arch Creek Road. And I'll proceed with item number 27, case number MHVIO 20210090. Item number 28, NJZ, case number MHVIO 20210091. Item number 29, case number MHVIO 20210092. Item number 30, MHVIO 20210093. Item number 31, MHVIO 20210098. Item number 32, image VIO 20210099. Item number 33, image VIO 2021001000. Item number 34, image VIO 2021000101. And as well as item number 35, image VIO 2021000104. Officer Perez.
Those are a lot of cases. Is the property owner present?
I am, sir.
All right. That's Francis Jacob?
Yes, sir.
All right. We'll try to hit each case separately so that we can simplify how we go about doing this. Let me hear.
Before you proceed, Magistrate, Francis.
Yeah, go ahead and swear him in.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
All right. Let's see. Who's handling this for the city?
That'll be me.
All right. Officer Perez, let's hear what the violation is about. I think it's about a fire extinguisher.
This first one's about a fire extinguisher, yes. All these cases are in regards to a minimum housing inspection that was done at the property. This first one is very specific to fire safety, and the fire extinguishers were expired, as well as missing a breaker bar and the glass, specifically the fire extinguisher between unit 1 and 4. At this point in time, the inspection was done on October. The reinspection was done in February. The final reinspection was done February 10th, prior to the hearing, and unfortunately, there was no compliance met. Actually, February 9th, sorry, the picture's there, where the breaker bar nor the glass is there, as well as the expired fire extinguisher that need to be replaced.
All right. The property owner there?
I'm here, sir.
Okay. What's the problem with the fire extinguisher? How come you're not in compliance?
I believe there's more than one extinguisher, and one of them is expired. I contact the company, does that. They promised they would come out, but they haven't done so. So I believe the extinguisher is fine. It just needs to be recertified. I can have that done.
How much time do you need?
Well, I'm going to need 60 days, not because of the extinguisher, because of the main issue is the window. There was one apartment that was in horrible condition. We had to replace 3 windows and a door. That was done without a permit, and that permit process takes a little bit of time.
Well, we're not here. We're not discussing the windows. We're discussing the fire extinguisher. Worst case scenario, you can go ahead and go buy one at Walmart, couldn't you?
Does not work, sir. It has to be done by a licensed company. The ones at Walmart don't apply to this product.
Okay, so you need what, 60 days?
Well, since there's multiple cases here, we're going to go over, I would say for all of them, encompass them in one. Yes. For this one here, it could be done in a couple of weeks. I just don't want to say this one, 30 for that one.
You know, when it comes to fire issues, electrical issues, fire, etc., I tend to be a little bit less lenient than with cosmetic issues. So if it's a painting issue, if it's a cleanup issue, you know, those we can, you know, we can be a little bit more lenient. But I'd hate to be without. By the way, is the fire extinguisher working?
Yes. There are 2 fire extinguishers at the property. The people who recertify all my extinguishers recertified one, but they didn't recertify the other. So it was an oversight on their behalf, and I've asked for them to come back. So they're going to do so. If you want to do 30 days, I'm fine with it, sir.
Okay, yes, I want to do it in 30 days because of the nature of the violation. So based on the unrebutted testimony of the city's code compliance officer, the photographs that I've reviewed and the evidence presented, I find that the violation as to the fire extinguisher still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Let's hear the next case.
The next case is at the same property regarding the AC units. The AC units are missing the condensation drains on all the units. So in essence, the drains just need to be installed with piping.
Wait, Officer Perez, because now we're kind of looking at very similar kind of violations, and I agree with the property owner that we shouldn't have, different deadlines for different things. Why don't we hear the four cases? The other four cases together, because they're kind of related to each other. The first one was kind of different.
Yeah, so it'd be the next 7 cases. We can hear them all together. It's fine with me.
Yeah. Let's do that to save time.
Okay, not a problem. So in this specific case, we have the AC unit drains that need to be installed. The next case would be for outdoor storage of miscellaneous items throughout the property. Some of them are belongings of the tenants. Some of them are belongings of the property itself. I'm guessing for maintenance and stuff. Holding down a little bit so that the pictures could come up. Additionally to that, there's a violation where there's cracked windows at Unit 4 that need to be replaced. There's also the sliding screens that need to be replaced and the window screens that need to be replaced. A lot of the windows don't have the screen. Some of them do, some of them don't, but the majority of them are missing it. There you can see the cracked window on the side there. It's a little hard to see in this picture, but there's another angle that was taken. You can see the cracked window there better.
Okay, I see it.
The next violation is regarding the landscape maintenance. There's patches of just raw dirt throughout the front of the property. This is, I'm guessing, due to tenants parking on the grass and pretty much cutting away at the dirt, or at the grass rather. So this needs to be resodded. The next violations for contact information. So per the requirements, the name, address, phone number of a contact person must be posted at the property, whether it be the owner and or the manager of whoever's managing the property that's not posted on the property. Additionally to that, there's one for a rotten wooden fence on the north side of the property that needs to be either repaired or replaced or removed altogether. The pictures should come up for that one now.
Okay, keep going.
And we have the one for the building permits required, which he previously mentioned for the windows and sliding glass door that were installed at the unit without permits. Those pictures should come up now shortly.
So these are new windows?
Right, yes. One of the units has new windows. And this will be the last case.
Are they impact windows?
I believe so, based off appearance, but the owner could speak more on that. You can see the new windows there, and I do have some other pictures from when I originally went out to inspect it, where you could see how they appeared because the property was painted. So
that was back in October?
That's back in October when the violation was originally opened, yes.
Okay, and when was your last visit?
February. So here you can see the new windows and doors, the sliding glass door as well. Those were installed pretty recently.
Without permits?
Correct, yes. As of as of February 10th, no permits were obtained.
All right. It's not a pretty picture, sir.
I agree.
All right. So how much time do you need to get this property back into compliance?
Well, all the things are relatively minor except the 10th one, which is the sliding glass doors and windows. I would need 60 days minimum on that. The rest of the things should be done in 30 days. So it's up to you.
You know that you need to get some permits issued on those windows, and they have to be in compliance with county code.
They are. They were installed correctly. They just need to be legalized, and a permit will be required.
Right. Okay. So you're asking for 60 days.
Yes, sir. I will contact Inspector Perez once the other items are done. So hopefully those will all be in compliance, and we'll just have to come back, or maybe not for the windows and doors.
All right. Just make sure that you proceed in good faith, because we just want the work to be done right.
Well, I don't know if Mr. Perez he really didn't say anything about this, but the property was in worse condition because we had a couple of tenants there that had not paid in 20 months. And when they left a disaster. So that's why the condition of the property became the way it is. So we recently refreshed the whole property. If he really didn't discuss that whatsoever, but I think he would tell you that the landscaping and the maintenance and the overall property, it looks much better now than it did before.
That's great. I appreciate that. I appreciate your telling me. So based on the unrebutted testimony of the city's code compliance officer, having heard from the property owner, observed the photographs and the evidence presented depicting that the cited violations still exist as to all of the cases, and excluding the fire extinguisher, which was treated separately, I find in favor of the city enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. So, sir, if you run into a problem with the windows, you come back and we'll talk about it. But everything else, you have 60 days to complete.
Understood, sir, and okay. I will come.
Thank you. Appreciate it.
One last question, sir. I have another case at a different property. Would it be possible that we could hear that now instead of later?
Yes, Madam Clerk.
The address is 2350 Northeast 6th Avenue.
Give me 1 second. That would be item number 12350 Northeast 6th Avenue, LLC. Case number CEBPR 20210007. Officer Aaron Barber.
Again, the property is at 12350 Northeast 6th Avenue?
Yes.
All right, Officer Barber, please proceed.
Good morning, Aaron Barber, City of North Miami Code Compliance. Excuse me. This case was open on September 22nd for a fence. This is a new case for a fence that was installed without permits. The fence runs along the south and the west perimeter of the property. The photos. Again, this was installed without permits. It's a repeat violation.
It's a chain link fence?
Yes, sir.
And it's on the perimeter of the property?
Yes, sir. It runs along the entire south side of the property and the west side of the property.
Are chain link fences permitted within the city in this district?
I believe so, sir. Yes. Yes.
Okay. All right. You in your note it states that this is a repeat violation. Same code section. Please obtain after the fact permits.
Yes, sir.
What do you mean by a repeat violation?
This property owner had been cited in the past for the same building without permit violations, and there are currently, I believe, there is something currently pending. Also, with Officer Beswick.
Was it the same fence that was cited, or a different?
It was a different building without permit issue at the same property.
Okay. Again, Mr. Jacob, what are we going to do about this fence that was put up without a building permit?
Well, it's a little more complicated than that, but what happens is the fence now is acting as a shield to protect the property because it's a construction zone. So it's on the back side of the property. Now, there was an existing chain link fence there too, and Erin really didn't say anything about that. We just refreshed the fence. And during our last hearing regarding the other violation, Officer Crystal Patterson had said for me to get another fence for the front of the property, which I did do so with her instructions to protect the property. So this is kind of protecting the rear of the property, and the front of the property is protected by a construction fence. So we have a big permit in place for all kinds of work to be done at the property that is almost approved at this juncture. So I mean, I could get a separate standalone fence permit if that's really what they would like. I don't have a problem with that. So I'd like to hear input from Officer Patterson if that's possible.
Who's going to tackle that question? Because
I've got to see if I can find Officer Patterson.
I mean, yeah. Well, I just see you. So
she's not. I don't believe she's an officer.
Yeah, you know what? I get
some days I am, some days I'm not. Magistrate, it's all fine. Mr. Jacob, I did. So there was a fence erected on the rear side of the property prior to Mr. Jacob and I having a conversation. This violation and what he's talking about are really two different things. We talked about the construction fence that he was asked to erect to enclose the location as it undergoes construction. But the fence in the rear that is in question today is indeed a separate issue. Now, I do understand, Francis, you're saying that there is a permit that or there's an application on file or a permit that's in the works with the building department, inclusive of this fence that was erected. Is that what you?
I don't think he said that, but that would be a good thing because that kills two birds with one stone.
Yeah, I don't want to lie. I don't think that fence is included. Like I said, the fence was there before, but it was in poor condition. So we did replace some of the things in the fence. Now, if you looked at pictures from the past, you would see there's a fence separating both properties. That's a chain link fence. Now, there were bums that were coming into the property, so we made the fence a little higher to prevent them from easily coming over. So it's a little ticky-tacky, but I'll pull a fence permit. I don't have a problem with that.
Does he need a separate permit, or can he join the fence to the existing permit?
That would be a question. I don't know, Mark, are you there? Yeah.
I'm back. Let me understand. He has a permit issued already? It
hasn't been issued, but it should be in the work.
Okay. So it might be best after that permit's issued because since it's already routing, unless it's a denial, can come back to a change, but it'll need to go through. If he does a change now, it will need to be basically reviewed for the reviewers to see the change, or he can, after the permit's issued, can do a revision to include the fence.
Now, Mark, with respect to, he's saying that the fence was already there and they fixed it. I don't know.
That's a new fence. That is the fence that I wrote the violation for. It was a new fence. It was taller. It was a newer fence. The old fence had been removed.
I prefer the what I believe the building official mentioned was get the first permit issued and then join the new fence to the permit instead of having two separate permits. I think it's silly to do double work. I would prefer tabling this issue until my next hearing to see if they have a permit by then. They can start the process of revising the original permit to include this new chain link fence. I think that's the cleanest way to go. This is not a big deal. I mean, it's a fence, the chain link fence. So why burden the property owner with an additional step when really he can deal with it later? So what do you think, Mr. Building Official? I'll defer to you. What do you think is best?
Now, with a chain link fence, that needs to, I don't know, that might need to go to zoning to see in terms of the height of that fence or the chain link. But he can definitely, after the permit's issued, put in for the revision so that way it goes through.
Well, I think the property owner can probably walk and chew gum at the same time. I think that in the process of getting the master permit, he can check with zoning to see if it's permitted under the code and get that work done with zoning before he even gets the master permit issued.
Okay, we can do some. He can do some coordination, and also my email is I can refresh it again on the link on the chat, so that way if he needs to get in touch with me, he can do so. So yeah.
So I'm going to table the fence issue for until my next hearing. So I think that concludes the cases. We're not going to charge you extra, Mr. Jacob, for having heard all these cases. But
Thank you.
I do like good faith compliance, and I'd like owners to be frank and upfront with me. So let's move on to the next case and good luck. Okay.
The next case, give me 1 second, Magistrate. Will be item number 37 through 38. Item number 37, the White House condo. And item number 38, the White House condo. Case number CEMHS 2021-00109, as well as CEMHS 2021-00111. Property address 13700 Northeast 6th Avenue. Officer Colson.
I have a Jacqueline Perez, if you can enable your audio and video.
Trying to enable it, but it's not. It's saying, okay. All right. Thank you. Good morning.
Please identify yourself. First, let me ask the clerk to swear you in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
All right, we're going to take on the first case, which has to do with the railing on the third floor. Ma'am, would you identify yourself for the record?
Yes. My name is Jackie Perez. I'm the property manager for the White House condo. And I just received today pictures of the bracket redone for the railing. I don't know if you can see. From my maintenance person that we have.
I'm not getting into the case quite yet. I'm just asking you who you are.
Okay.
Okay, and you're the property manager, and you've received notice of the violations, correct?
Yes, sir.
Okay, so now I'm going to turn it over to the city to present the case.
Once again, good morning. I'm Officer Colson. The case is the White House condos, a minimum housing standard investigation. Yeah. This is for the railings. It was very loose. It was done. Original violation was open in September 27th, 2021. As I came out to the property, I noticed the brackets were broken. I also shook the hand railings and the hand railings were very loose. As of my final inspection, the brackets were still broken in February. I shook the railing, it was still very loose. So therefore, the violation at the time of my final inspection still existed. I'm sorry, Judge, this is a new case.
Okay. And is that the only picture? Yeah, I see them rust.